Did you know that 53% of adults don't have a will? Whether it's because you think you're too young, don't have enough assets, or simply just haven't gotten around to it, if you're part of that statistic, don't worry, you're not alone. I'm Grace Demoro, Wills Manager at State Trustees. My team and I have all practiced law at various firms across Victoria and bring our wealth of knowledge to State Trustees, where we make complex legal matters easy for you to understand and support every client to feel confident and at ease. We can help you prepare a will that reflects your unique wishes and circumstances, and also assist with setting up powers of attorney so that a trusted person can make decisions on your behalf if need be. We can also guide you through nominating an executor, whether that's a person you trust or a professional organisation like State Trustees. I'm going to take you through the will writing journey to get you comfortable with the process of creating a will that suits your needs. We want you to feel empowered and confident, knowing exactly why creating a will is important and how to go about creating your will with the help of our professionals. So let's get started. For some of you, it may be the first time you're considering preparing a will. For others, you may already have a will, but are thinking about whether it's time to update it. Wherever you're at with your journey, it's helpful to understand what to expect so you can feel comfortable in taking the next steps with State Trustees. Firstly, what is a will? So a will is a legal document that outlines your instructions about who you want to inherit your estate, including pets, care for your children, and be your executor. When you die, your assets are referred to as your estate. Your estate can include things such as real estate, so property, your car, bank accounts, other personal items such as jewellery, and even your beloved pet. There are other complex circumstances that we can help you with as well, such as how to deal with your small business after you die, what to do if you're a beneficiary of a trust or would like to establish one in your will, or if you'd like to donate to a charitable cause. A will must be a written physical document signed and witnessed in a specific way. No videos or voice recordings are acceptable. By law, a will can only be for one person, meaning couples both need a will each. That being said, at State Trustees, we offer couples appointments and can mirror your wills so they are prepared in the same terms, which is very common for couples. A will appointment is a service that caters to everyone, whether your wishes are simple or complex. A professional will writer meets with you in person to guide you through the decisions that need to be made and, of course, answers your questions as you go. Next, I'll take you through a step-by-step guide to writing a will with us and what to expect when you're writing that will. Meeting with any professional can be daunting. However, our team of will writers is here to make the process easy for you. With care and expertise, we'll guide you through each step of creating your will to give you peace of mind that your financial and legal affairs are in order. Our will writers write wills for people of all walks of life and can draft a will that will give effect to your unique wishes and circumstances. What happens before your appointment? Ahead of your appointment, you'll be asked to complete a pre-appointment questionnaire. We will send this to you via email, or if you'd prefer, we can also post it out to you. It's important for us to get to know you and your unique circumstances before we meet, so that your appointment runs as smoothly as possible and your will is ultimately as unique as you are. Think of it as going to the supermarket without a shopping list. You might remember some of the things you need, but you're likely to forget some important items. That might mean another trip to the supermarket, wasting your time and effort. Similarly, if you don't complete your pre-appointment questionnaire before your will appointment, important details could be missed, making it harder for us to create a will that truly fits your needs. It might also mean that you require an additional appointment, which could ultimately delay the will-making process. The pre-appointment questionnaire asks for important information, including your personal details, relationship status, and history. Details of your spouse and any children, including who you might like to look after them after you pass. Details about the assets that you own, including property, bank accounts, investments, vehicles, superannuation, and other personal items. Any liabilities and debts that you may have, such as your mortgage or other loans. And finally, any insurance policies. In some instances, you may not have all of these details, such as the value of your home or super, or you may find it tricky to get them all in time for your appointment. That's fine. These things won't prevent us from preparing a customised will for you. Simply complete the questionnaire as best you can, but don't worry if you can't fill it all in. Next, I'll talk about what to bring to your appointment. For your appointment, we'll ask you to bring two things. Firstly, photo ID, such as your current driver's licence or passport. And secondly, your pre-appointment questionnaire, if you weren't able to provide it to us in advance. Now I'll talk about what happens during your appointment. We'll get to know you by discussing your pre-appointment questionnaire and answering any questions you may have before we get started. Then we'll step through each section of the will. We'll discuss appointing an executor. This is a trusted person or company, for example, such as State Trustees, who will manage your estate according to the wishes outlined in your will. Specific gifts to your loved ones, nominating a preferred guardian to take care of minor children, nominating a willing caregiver for your pets, donating to a charity or cause, which you can either do directly or via State Trustees, provisions for any trusts to be established upon your death, and finally, how to distribute your residual estate. You may not know that we're experts in other areas too. In addition to preparing your will, we can also prepare an enduring power of attorney or medical treatment decision maker, formerly called a medical power of attorney. These documents allow you to appoint a trusted person or company, such as State Trustees, to manage your financial and legal affairs if you're unable to do so yourself. You can also appoint a trusted person to make personal and medical decisions on your behalf, should you ever lose capacity. I like to think of a power of attorney as a bit like giving a trusted friend a spare key to your house. If something happens and you can't get home, they can step in and take care of things and ensure that everything runs smoothly in your absence. Without a power of attorney, there might not be anybody authorised to handle your important matters when you really need help the most. Next, I'll talk you through finalising your will. Once we've prepared your will, we'll read it over with you to make sure you're comfortable with it. Once we confirm that it reflects your wishes, you'll sign the will in the presence of two witnesses, and the result will be a legally valid will. We can safely store your will in the Victorian Wills and Power of Attorney Bank and give you a copy to take home. After you make your will, you should get in touch with us if your circumstances change. We can meet with you again to prepare a new will that suits your updated circumstances, such as having children, getting married or divorced, or buying or selling assets such as property. Something many people are surprised by is the fact that your will is revoked when you get married, unless your will is made in contemplation of that marriage. This means that any previous wills you made become invalid and you would need to create a new one to reflect your current wishes and circumstances. On the other hand, if you were to get divorced, your will remains valid and only the parts in your will that favour your former spouse are automatically revoked. For example, any gifts made to them or their appointment as your executor. If there's anything you'd like to discuss with us before making a booking, please get in touch and one of our team members will help you. Call us on 1300 138 672 or visit our website at www.statetrustees.com.au. In addition, if you're in a regional or remote part of Victoria, or if you have mobility issues, you may be eligible for a virtual appointment or a home visit from one of our representatives. Just keep in mind that additional fees do apply for off-site appointments. If you have questions about making a will, we have a resource section on our website dedicated to answering them. Visit our website at www.statetrustees.com.au/FAQs to find out more. Next, I'll go through some common FAQs. Firstly, what happens if I pass away without a valid will? If you don't have a valid will when you pass away, you won't have a say in how your estate is distributed. The question is, can you live with that? The law will determine who benefits from your estate and who is responsible for managing the process and making final decisions. This may not reflect your assumptions, expectations, or wishes. Your estate may take an extended period of time to finalise, more than 12 months. The cost to settle your estate may be significantly more than if you had written a will in the first instance, which ultimately wears down your estate. So every Australian needs a will, even if you're single or without dependents, even if you don't have many assets or if your circumstances are quite straightforward. Think of it as an act of kindness to your loved ones, knowing that your affairs will be in order when you pass away. What are the traps I should avoid when making a will? So there are a few traps that come to mind. Not getting the help of an expert witness to guide you through your options, not appointing an executor who is willing or able to act, not including a clause about your residuary estate, not storing your will safely and securely, not dating your will or having it signed before two witnesses, not using the same pen to sign your will, not using a consistent signature across each page of your will, and finally, attaching things to your will. Can I include superannuation in my will? Superannuation generally does not form part of your estate because it's held in a trust within your super fund. This means that your super fund is the trustee and they are responsible for deciding who your super goes to through the rules of your super fund or through a binding death benefit nomination that you put in place. You can make a binding death nomination direct to your super fund, which gives your fund instructions on how you'd like your super benefits to be paid upon your death. This can include your spouse, children, or other dependents. We can also include a note in your will about how any proceeds from your super should be distributed if it is ultimately paid to your estate. Can I donate to multiple charities in my will? Yes, our dedicated team can help you with choices based on the size of your gift, the charities or cause you want to support, and the impact you want to create. You can include one-off gifts in your will, or you can leave a legacy gift in your estate, where your gift can be held in a charitable trust that provides ongoing financial support to your chosen charity or cause. This is done through an already established trust, like the State Trustees Australia Foundation, or via a private charitable trust, which we can set up for you. More information about charitable giving is available on our website if that's an area of interest for you. Who can make a will? Anybody over the age of 18 years with testamentary capacity can make a will. Testamentary capacity means that the person making a will understands what a will is, understands the nature and extent of their estate, and the potential claims of those who might expect to benefit from their will. The will maker must also be able to make decisions about how to distribute their estate without being influenced by external pressures or other issues which may affect their ability to think clearly about their will. What's an executor and why is it important to nominate one in my will? An executor is someone you choose to manage your estate and carry out your wishes after you pass away. Your executor will ensure that your assets are distributed according to your will, handle any outstanding debts and taxes, and oversee the overall administration of your estate. They can also apply for your death certificate, apply for a grant of probate, handle debts and bills, prepare tax returns, and ultimately resolve any estate disputes if they arise. Why would I consider a professional executor like State Trustees? Many Victorians prefer not to burden their loved ones with the complicated financial and legal matters that an executor is responsible for. That's where a professional executor like State Trustees can be a really great option. We also have an executor assist service to help support executors fulfil their obligations. You can find more information about this service on our website. How do my executor or family members find my will? The simplest answer is that you can tell them where your original will is located. You can choose to deposit and store your original documents in our secure will bank or keep your documents yourself and only register the location with us. If you decide to store your will at home or at another location, State Trustees can register the location of your original documents in our Victorian Will and Powers of Attorney registry. This is a free service for all Victorians and can offer you peace of mind knowing that the storage location of your documents is recorded securely with us. Keep in mind that before we provide details of your will, your executor will need to prove their identification, plus a death certificate before we provide them with your original will. Thank you for joining us for today's walkthrough through the will writing process. If you have any further questions, please don't hesitate to reach out to us. You can call us on 1300 138 672 or visit our website at www.statetrustees.com.au.